I would wish to take your lordships principally to some very interesting underlying juristic principles. Because the lordship have now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the Speaker. That's going to be the bulk of my argument. But brothers, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything. I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where your lordships has double whammies and triple whammies. Let me explain how. My Lord Malus put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of Constitution and statutes is that if intentionally a constituent assembly in its amending power of the Constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is axiomatic. It is obvious a puny contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are at least two circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, your lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he's acting. Now, as the governor, most of all, is supposed to know the Constitution. All of us are supposed to know the Constitution, and ignorance of the law is no excuse, much less ignorance of the Constitution. There is no system, and I'm not talking of your lordship's narrow question of trust vote, non-trust vote. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. Well, there is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking a lordship, Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing. I'm on the context, Wallace. People are here going around merely on the assumption of a split, then the lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras. There's more than 4 paras or 3 paras in the EC. We'll just give the paras. Yes. Now, Millets, therefore, your lordships and those cases don't have to be given to your lordships of elementary forms of interpretation that if I delete something, your lordship gives effect to the deletion. I'll supply them, Millets. It's not necessary to do it. The second answer. or the second one is response in the larger context of that query. So this is the first response. The second is, well, your lordships decides cases, not that your lordship decides the narrowest of narrow issue, lordship decides the whole context. But your lordship doesn't decide beyond the context of a case. Your lordship is very careful, otherwise well, the things of biter and all that come in. And your lordship doesn't have time to spend on hypothetical questions. But let us see the context. The context of this case can be divided into broadly three or four categories. And that context makes it clear that your lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now, that will be awaiting your lordship's decision on nabab. So, phase one or part one of this context is disabling notice. Your lordship must decide in nabab. That's the whole argument we made for 2 days. But clearly, the context is that's step one. And if that is wrong, then a lot of things fall down. And that is wrong in case your lordship doesn't agree with the literal text of nabab. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, is our cases again and again talking of two things: the evil prior to 84, the object of plugging that evil, the mischief rule, and what your lordship is doing by the 10th schedule. The third is that if your lordships accepts that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then 2-1, A or B as the case may be, has to be decided first. It's logically prior to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept. I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, Nagaland speaker may take 6 months, a Manipur speaker will take, that's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by your lordships. Inter alia, by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. The other aspect of this, which has to be given a lot of weight is, apart from what we just talked about, the trust vote, people tend to forget that in almost every assembly, there is a very interesting rule. You cannot bring repetitive no confidence motions also.
6 months.
Your lordship knows 6 months. So I bring a no confidence against you, I lose it, I can't come after next week again say I have no confidence against you. So, the next facet of this is the processes within the parliament and assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, your lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving lordship in addition the larger context. Not even an attempt. Whereas, as they say, the proof of the pudding is in the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whoever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, I mean, it is not that your lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. Well, it would really amount to a very strange thing where the governor would, well, governors are now, obviously, if your lordship reads the debates of Mr. Ambedkar and now, there's a vast difference. But governors are also creatures of political connection. The governor would say, I see a group of people here. Why are you bothered about moving a no confidence? Come to me, we will see something. There's no need for us. The assembly gets substituted. You'll be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. Now, having given that answer, let me turn to my larger point on which I was really going to address your lordships. And give your lordship just bullet facets, and then I will give your lordship the material underlying it, the juristic principles as to why your lordships should deal with the matter here. Now, I understand that it is easier not to deal with it here. It is also equally possible not to deal with it here. There is a speaker. My lord has heard enough facts. So lordship will take those facts as given. I will touch upon the facts here and there, but mostly no. In the event that the facts and the context suit your lordship's discretion on this issue, should your lordships in law juristically refer it or should you hear it is my respectful submission. There are four or five legal facets. Then I'll give your lordship the case law. The first is that there were two one negative and one positive order by this Honorable Supreme Court. That should be remembered. In whichever way it is worded, the negative, I'll call it injunction, on 27/6/2022 was that by the expedient of extending time, the Speaker was effectively de facto could not pronounce on disqualification. It is nothing but an injunction in substance.
Till 12th.
Till 12th, correct. Then events took over, but my lord is right, till 12th. Therefore, let us look at it because the lordship is always a court of substance. We can camouflage in so many forms, but your lordship ultimately sees this in substance. It's a judicial injunctive interim relief qua a speaker's future action under the 10th schedule. That is the correct way of putting it. It is a judicial interim intervention. It's a negative injunction. And the second was a positive injunction, if I may call it, or an order of 29th, allowing the trust vote to be held. So not injuncting the second day, injuncting the first day. So there is a negative judicial intervention followed by an affirmative judicial intervention. I am not making any value judgment. Your Lordship would have heard it next week, 2 weeks later. Who knows, but everything could have been reversed. I mean, I'm not saying that at all. I'm not saying right or wrong. But I'm saying one thing is clear, that the formation of a government, I'm making a neutral statement, I'm not allocating, is clearly the direct and inevitable result of the combination of these two orders. Your Lordship could have heard it next week and upheld it. So Lordship would be right. Your Lordship could have reversed it. Your Lordship would be wrong in the interim then. That's not the point. The point is, let us not see this case in the abstract, in an ivory tower, unrealistic approach. Let us see it in reality. We have to smell the constitutional coffee, if I may say so. The reality is this, that absent these two negative and positive orders, your Lordships cannot have this consequence of a change or a new government. This will have, correctly an effect on your Lordships needing to decide this year. Then, the second aspect, I'm only giving the legal bullets, I'll cite the case law later. The second legal aspect, the juristic principle, is the language of that order. Now, we all say it casually. Sometimes your Lordship is also made to say it casually. But these are terms of art. Your Lordship has used them for decades and centuries in law. And these common law terms of art have to be given effect to. Don't go to the page, just note, your Lordship's order on 29th read like this, one line, quote unquote, subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, unquote. That's your Lordship's order. This is my second facet. Subject to the final outcome of the instant writ petition as well as the writ petitions referred to above, which means the whole batch of writ petitions. By then, many petitions had come. What is the meaning of this frequently used phrase? And normally the phrase doesn't come up. Your Lordship has some very, forget this case for just 1 minute. Your Lordship has some very interesting examples in building law and construction. Well, the first time your Lordships ordered demolition, the first time, not now, of a 20-story structure was almost 15 years ago. Ironically, I think the second one was also from Lucknow. Both are Lucknow examples which came here. Your Lordship had passed only subject to. Construction will go on. Ultimately, your Lordships held against. Your Lordships ordered demolition. Demolition, in that sense, with people living and concrete and mortar in the building, is much more irreversible than merely a political thicket or a scrambled political egg created from 22 to now. Now I come to what subject to means. The object of this phrase subject to are two and threefold. One is that your Lordship's speaks in rem, not just bilaterally between the parties. Your Lordship speaks to the whole system, to the whole world. And second, your Lordship is giving a fair warning that everything which is happening after this is subject to, but on your risk and cost. And thirdly, your risk and cost means all consequences, equities, vested rights, all status quos you create each day after that. Is it your risk and cost? We are warning you. Don't blame us later. That's the meaning, of this, and I'll cite a case presently on that. Therefore, the moment, either Lordship doesn't say it, the moment your Lordship says that, no one can come and plead equities, vested rights, events, scrambled egg, irreversibility, etc., etc. Because your Lordship takes into account this in advance. If your Lordship passes subject to today, it is different from passing in 2022 June. The fourth facet of law, which I will develop in a moment, is that third. I'm sorry. What is third? Third. This is This is Manus now. It's called pointillism, Manus. Pointillism. It's not a bad technique, Manus. It makes it for specificity and a certain amount of clarity. It may not always be. It is liable for some intellectual property protection also, Manus.
Correct. More than anything, you will know where you are going.
Now, Manus, the third one is para 110 of Quixote, which your Lordship has seen right at the beginning of the Navam Rebia arguments, but Lordship may kindly be reminded of that. Just turn to 110 in Manus, the first compilation, PDF, page 74.
Or judgment compilation.
Judgment compilation. Or basically, Manus, the very strong constitution bench injunction when the jurisprudence of 10th schedule was starting. Quixote is Manus, virtually the first. I mean, there were some cases, virtually the first, certainly the first constitution bench and the most important 10th schedule judgment at that time. Manus. They started this jurisprudence with this great warning and mandate. PDF 134 or 74? 74, the Kyoto starts at 134. At 134. Para 10. Para 110. The full thing is put here. Full thing is correct. In view of the limited scope of judicial review, may I read it?
Yes.
In view of the limited scope of judicial review that is available on account of the finality clause in para 6. So, Your Lordship gives basis for it, finality clause in para 6. And also having regard to the constitutional intendment and the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review cannot be available, mark these words, cannot, Constitution bench is saying, cannot be available at a stage prior to the making of a decision by the Speaker, Chairman, and a quia timid action would not be permissible jurisdictionally, threshold, nor would interference be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. But I'll just pause here. It has some very startling consequences. If Your Lordship reads this, it's a constitution bench. It makes only one exception. When I, the Speaker, by an interim order disqualify you, that has happened hardly ever. Well, this happened once or twice, but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future. Well, I don't know. But today, well, it's hardly any case. But
you are giving the idea.
No, well, Quixote gave that idea. Quixote has given the idea already. But that's why I'm saying from 92 till now, it has not happened despite Quixote's idea. I mean, it may have happened one or two cases, but hardly ever happens. Yes, Kuldeep Bishnoi case, etc. But Malaz, in that exception apart, it is per se jurisdictionally bad. So therefore, Malaz, a perceived error of the Speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the Speaker is wrong. Nobody is conceding that. Let us assume that the Speaker is grievously wrong. That will not justify circumventing of a constitution bench by saying, normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Well, let's take an example. Your Lordship has applied that example for decades. It is not something strange at all. Quixote was, according to me, saying the obvious in a much more important category. Your Lordship has done it for lesser category. Well, as your Lordship finds genuine problems in an election process. When an election process starts, your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, Malas, the position which by a combination of the positive and the negative order inevitably led to the change of government possibly was also constitutionally wrong. Had your Lordship had occasion to discuss it in the 2 weeks following that, your Lordship would have rectified it. Today, Malas, it cannot be a bar merely because of passage of time, because this is on the face of it contrary to your Lordship's constitution bench. And Malas, an error of the Speaker was irrelevant. In fact, Malas, he hardly had opportunity to commit many errors except perhaps as the 2-day notice that would have been decided. I've cited, Lordship members, 2 cases I cited in the Navam Revia, where 3-day notices were sufficient. Yedurappa and, Yedurappa was the other way, Malas, Nayak and Balasa, Patil. Srimant Patil. Three judges, 3 days, sufficient. When the rule said 7 days, I hope my Lord remembers that. In Navam Revia, I cited those cases to your Lordship. Rule said 7 days, 3 days notice. 2-judge bench in Ravi Nayak said okay. 2-judge bench in Yedurappa doubted it. 3-judge bench subsequently affirmed the Nayak principle, despite noting and citing Yedurappa. Then, Malas, the fourth facet is that the more important and the more general principle, but equally important, that your Lordships respects co-equal organs. There's a whole other line of cases. When I come to my notes, I've cited some of them, where your Lordships is very careful, because your Lordship now doesn't think of an individual speaker, but of the institution, where your Lordship doesn't enter into co-equal branches unless there are compelling reasons. So respect between and mutual balance between judicial and legislative organs is the other legal principle which has to be kept in mind, and all this goes towards making the non-interference principle at that interlocutory stage. Then, Malas, the other facet which your Lordship in case law has used is, there may be a rarest of rare exceptional situation where your Lordship passes interim orders, not in this case, no case, I'm saying generally. Now I'm not going to tension you, to maintain a status quo. But your Lordship is very, very sensitive and cautious and careful to create a new status quo by an interim order. Maintaining a status quo and leading to the creation of a new status quo are two, Malas, different principles of law looked at and dealt with differently by case law. Here, clearly, a new status quo was created. The fifth principle, Malas, is actus curiae. Obviously, actus curiae arise in the event that your Lordship finds that I'm partially right or fully right, not otherwise. But if your Lordship finds, then, Malas, your Lordship reverses the most intertwined situations, because the Lordship never allows the act of court to do any harm. Actus curiae nemine gravabit. The sixth facet is, Malas, that if there is a right made out, I'm sorry, my apologies.
No, 6.
Next. Actually, I dictated these later on, so my numbering is also in A, B, C, D, E, F, G, because the main submissions are below in 1, 2, 3, so I don't have those numbers. But because your Lordship is right, I'll say next, your Lordship will have your own numbering.
Yes.
Well, is what your Lordship, I'm sorry, this is not that we are using Latin. Your Lordship has warned us in recent judgments against using Latin, but these are basic principles. The other one, is ubi ius, ibi remedium. If your Lordship finds that I have a right, in this case a constitutional right, made out by all this which we have been arguing, then, at the end of that right to say that I am remediless, The remedy which is effective and real is only a reversal of the status quo ante, as would stand immediately prior to the consequence of those two orders in June. The consequence being the change of status quo on 4th July? 4th June. 30th June is the swearing in. 30th June is the swearing. I'm sorry, not 4th July, 30th June. So it must be a status quo ante. In the event that your Lordship applies the principle, obviously EB remedium doesn't arise unless there is EB use. If I don't have the use, I don't have the remedium. But on the assumption that I have, then your Lordship will not be told it's a fait accompli.
So what would then be the consequence, Dr. Singhvi? What does the court then, logically, what would be the directions of the court?
Well, logically, the direction is that that particular act of swearing in is wrong, and your Lordship will have the whole thing done again. Your Lordship could then, to give a Lordship, your Lordship give a substantive answer.
Yes. What will be the substantive directions then?
Yeah.
Just to...
Now, I am giving your Lordship a substantive direction. Of course, I will develop the law which is yet to come. In the event that that is correct, and that is the majesty of the law, that is what your Lordship means when your Lordship demolishes 25-floor buildings. And the message goes that your Lordship is ultimately establishing the supremacy of the law. Supremacy of law is by no other means except by result, by actual de facto on the ground result. The rest remains paper and words. It would be a reversal of that oath. I'm being very formal and constitutionally proper. A direction.
Oath is on 3rd.
No, I thought 3rd is 30th. I also thought 3rd. That's why I said 3rd. Apparently, it's on 30th.
Because on 29th...
that's right. That's correct. That's correct.
Of course, Thackeray resigned 29th evening.
That's correct. Doesn't matter, 3rd or 30th, but reversal of the day before that. Second, for the purity of the process, your Lordship will, there is still a Deputy Speaker, should decide what he would have decided but for your Lordship's injunction. Because your Lordship is now counting the status quo ante on the but for test. But for these two orders, what would have happened? Obviously, only this would have happened. There would have been no swearing in and there would be a decision. It sounds sometimes difficult, but imagine. Yes.
So far,
kindly note.
Dr. Singhvi.
Yes.
When you are on the interim injunction, not granting interim injunction on 29th and to see that the status quo ante is maintained, it was only with respect to the floor test on 30th.
And he resigned. That's what, and Roshi was asking. No,
1 minute. You can read the... on 30th, on 29th, he resigned. The order dated 29th, not granting injunction was very clear. That the floor test on so-and-so will be subject to the... Floor test on 30th will be subject to the ultimate outcome. Correct? Now, in that case, correct, raise the question of status quo ante.
Yes,
correct.
I'm very grateful.
On the basis of the 29th injunction or not granting injunction.
I'm very grateful for a query. Your Lordship was put it in a different way earlier. I must answer it again. It's very opportune at this moment. There are two answers. One answer I gave 3 minutes ago, your Lordship's court is a court of substance. Always, not of form. Let me develop it. I'm answering only my Lord's query. Paramount is substance, the heart of the matter. It is true that on that day, on 29, nobody would know what would politically happen on 30th. And it is true that the technical word used is trust vote. But what was allowed to go on was a test on the floor, which is inevitable if 39 vote against. The one and only foregone conclusion, instead of suffering the humiliation of a vote, is to give up in advance. I mean, we are in a real world. There is no arithmetic, no science, no physics, which can change the result on 30th. If these people who comprise this, so the floor, I argued the matter on 29th and the earlier dates. One of the main arguments was that the moment your lordship permits these people to vote, we were seeking an injunction. Where, how can there be a trust vote with a tainted, how can you have a swimming pool with some part of it tainted with poison?
No, therefore your submission seems to be
that was not accepted.
That not granting the injunction,
yes,
correct, would in fact had facilitated those 39.
No, it was an additional argument, Balas. I'm very grateful. One argument was that this trust vote is, Balas, completely unreal and futile because you have not excluded the tainted fruit.
On the other hand,
the other argument was, Balas, that if your lordship has stayed that, stay this also. That was a more important argument.
The flip side would have been that
stay both.
Dr. Singhvi, if you had faced the trust vote,
yes,
on the 30th,
yes,
these are open. There is an open vote.
Yes, yes.
Right, because you have to, because that's the whole principle of the whip. If you had faced the trust vote and lost, then it would have been clear as to whether these 39 people made a difference, how they voted, and whether that made a difference to the ultimate trust vote.
So we did not do it. It's a given fact. I can't change it. Right, Balas?
Right.
I'm answering. Balas, let me answer this also.
And the voting pattern would then determine as to whether these 39 who are otherwise facing disqualification motions,
yes,
whether they affected the trust vote or otherwise.
Well, I appreciate. No.
If you had lost the trust vote only because of these 39,
yeah,
then you absolutely a plausible point that, look, these disqualifications, if they get disqualified, then I win the trust vote. Isn't it?
Let me. So the first part is the conceptual.
I mean, the area is not free from doubt. The reason we are putting it to you is because there is a constitutional question in our mind. That's the.
I hear your lordship loud and clear.
Yes.
Let me, because certain given facts for us, we can't argue about. The fact of the matter is, nothing happened on 30th. The man did not go to the trust vote. No doubt about it. Now, the first conceptual answer is, we are now on what I have been saying and Mr. Sibal has been saying earlier were legal errors. Whether they were or not, the lordship will decide on 22nd, 23rd orders. But the argument regarding 29th order was that either you should not have stayed that, but if you stayed that, stay both. You can't stay that and allow this vote to go on.
Right.
That's the first point to be remembered.
If you have stayed the disqualification, then stay the trust vote also.
It's very unfair and uneven and non-level. Well, if your lordship is hearing the matter next week, I believe it was on a Monday next, it was listed. Then both could have been held afterwards. The lordship, as well as in the Karnataka late night matter we did, the lordship said, not today, next morning, it will happen at so-and-so time. The reverse is also true. Don't have it there, have it after 4 days.
So your argument to therefore restate your argument, what you are really arguing is this, that once you stayed effectively the speaker from deciding the disqualification petition, then you should have stayed the trust vote also, because one was linked to the other at the least.
The word linked, inextricably intertwined, absolutely. And that is the answer, the first answer on the conceptual query raised by my Lord Justice Shah.
No doubt.
It is true. Technically, one is a trust vote, one is a floor test, one is nobody comes.
But you're right. I mean, because
substance
at the trust vote, those people were going to vote.
So that's the first. Now, second, no, I will go further. Since your lordship has put a different question.
But still, Dr. Singhvi, the problem still in your path. I mean, the problem still arises.
It would have been shown on that.
The consequence of these 39 would have really.
No. So let me show. Therefore, now that will not affect this question. Let me be conceptually clear. Yeah. My Lord's query is right, but that will not affect the question I'm arguing now. That will affect, as and when your lordship takes up the disqualification and says that we find that no disqualification occurs because we don't have sufficient proof to disqualify. That's all that will mean, Maharaj. It will only mean that I have insufficient evidence. And I'll tell lordship why lordship
Nabam says, applying Nabam here, the speaker could not have decided. I mean, I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that well, these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification. It's a clear split. What is the ultimate consequence? That these 39 have to be taken out of reckoning on the trust vote which takes place.
My lord is back to the chart figure.
Which these 39 have to be taken out of reckoning.
We have answered the governor point. Lordship is not coming to the governor. Governor is constitutionally barred. I'll deal with the chart in a minute. Well, today, can your lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my Lord Chief Justice
Did you not really?
The governor could have acted on that.
Did you not preclude a consideration of this argument by your own failure to face the legislative assembly?
So there are 2 or 3 answers.
Because also, I'll tell you why, and we'll rise then and we can reflect on this at lunch. Because today, what you are really asking for, and we're not saying that you are wrong in asking for it, because first principle, the court said subject to the outcome. So therefore, we have to now treat it, if we come to the conclusion that you are right, then ignore all outcomes.
And my lords have done it twice. In 10 scheduled cases of big moment, twice.
Fair enough. But before a constitutional court does that, namely to set back a status quo ante constitutionally, we must be in a position to say that, well, there is an arguable outcome which would matter.
Absolutely.
Which would make a difference.
Absolutely.
If whether there would be a difference or not is really foreclosed by virtue of the fact that you prevented that difference from emerging before the court.
Why it is not foreclosed? I understand, my lord.
Let us think on this. We come back at lunch.
I'm deeply aware. Your lordships put that question just on rising. So let me answer, ABCD, that particular question. I'll continue with my sequence after, but lordship put that question, that had you allowed possibly the 30th vote to have worked itself out, or other things, then your lordship would have had, so to say, an actual test.
3 baje
The courtmaster didn't to come with the courtmaster. Now, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your lordship put in a nutshell. There are 5 very interesting answers to it. Directly to your lordship, very important query. And a related query of Justice Shah at that time. A. This act was followed on 30th by the swearing in along with BJP persons. Just note, I'll make the point in a minute. Just note, 30th June was the swearing in along with senior members of the BJP. 3rd of July, 3 days later, the direct answer to my lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your lordship will call it, or a vote of a virtually identical nature happened at the speaker's election. Now, clearly, there is a whip, there is a direction. You can't vote for the speaker. You are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required. This is a 2-1B without going into a single fact. I'll give your lordship the judgments. Each of these acts your lordship has already held in judgments to be a direct violation of 10th schedule without any facts required. Well, if I vote for a speaker and I'm under a discipline of my party, you can't vote for him. You don't require anything else. You only need to see the voting. Did I press that button or not? Nothing else is required to be seen. That is on 3rd. So what my lords is saying, nothing could change between 30th and 3rd. 3 days, well, no majority would change. No numbers would change. Then the third answer is the 4th of July. Again, an identical trust vote took place for Mr. Shinde. Again, you were told not to vote. Again, you voted. Same people, same vote, same system, same everything. 4th of July, a trust vote in the affirmative for Mr. Shinde. So my Lord has ample proof. My Lord rightly said, how will we know? We'll have to go into something. This is a very, very interesting case where 2(1)B requires nothing, 2(1)A also requires nothing. Normally, your Lordship, 2(1)B can be a per se completely, but something may be required for 2(1)A. Here is a case where both 2(1)A and 2(1)B are per se. Very rare combination. Fourth reason. So swearing in with the BJP, it's on cameras, everybody sees you. 3rd July Speaker's election, 4th July trust vote of Mr. Shinde. Now, the fourth reason. Even the acts, if your Lordship were to go back, now, these are enough. I'm only giving by way of addition. I don't need to go back. I'm now giving your Lordship the seemingly contentious issue, seemingly, which is not actually contentious. The seemingly contentious issue, which is not contentious, is that on 21 and 22nd of June, you did not attend a meeting despite a direction in writing. Please attend the meeting. The direction is on record. Your non-attendance is on record, admitted. My Lord will now look at it in demurrer. I'm trying to make it as simple as possible. No investigation, no inquiry, no evidence. Just look at it in demurrer. Second event is that you went with the BJP and others to meet the governor on 30th June. That's also admitted. It's on record, in the press, on photographs, on press reports. Admitted, no evidence required. As your Lordship noted, this visit on 30th led to the swearing in, which I've already mentioned. Now, which of these will not fall foul of 2(1)A? Forget 2(1)B, Malus. 2(1)B is more per se. Malus, what can be the defense? I'm asking myself hypothetically, Malus. Your Lordship will also see the practical. Yes. I mean, what can be the defense? That these photographs are forged, all the media is forged. I was in Malus, Timbuktu, I never went to the governor's house. That can be a valid defense. Nobody's taken the defense, you can't. Now note two more interesting things, brothers. Rana, para 48. Lordship knows Rana very well, brothers, the Constitution bench. Specifically says that the act and conduct of going to a governor would constitute disqualification. That's Constitution bench. Citation the 2007 4 SCC 270 PDF page 834 of the first compilation.
It was read yesterday.
Read. Only Malus para 48. So
Rajendra C. Rana.
I beg one.
Rajendra C. Rana.
Correct, Rajendra C. Rana. So Malus, this is very interesting again. The fact is admitted and the law is covered. What is it that a Lordship has to do by way of an exercise is my question to myself. With great respect, nothing, Malus. Fact is undeniable, admitted, and the law is covered. And covered too by a Constitution bench. We are not saying, Malus, I can even, Malus, bow down with great respect in a very contentious issue. Your Lordship says, why should we not send it back? There is no issue here. Now note the second judgment, Srimant Patil is the citation. Srimant Patil is the Karnataka judgment. Para 174 and 176. Para 174 and 176. The citation is 2020 volume 2 SCC 595. Three learned judges. This is the
2020.
2020 2 SCC 595. The PDF page in the first law compilation is 1249. It's starting page, I'm sorry. The relevant para is 174 and 176. At PDF page 1307 and 1308. This holds the second point. Not attending meetings is culpable. This is the inception. 21st June and 22nd June, you didn't attend meetings. This judgment holds that not attending meetings is sufficient to disqualify. So, Manoj, in this 5 sets of facts, facts are admitted, law is covered. Now, you can always say that we want to do this, we want to do that, but if there is a purity and a social and a political evil to be controlled by 10 children, then this requires no adjudication of any kind except the formality of a notice and looking into it. And what is the, even till today, what can be the defense of this? I am prepared to accept a new defense today. There cannot be a defense to these things. This is the light of, but I had finished on subject 2, putting to you notice and risk on your own risk and cost, telling you in advance, warning you. Now, let's kindly consider, why is this principle? It is, for what the phrase by Lord is used time and again, the majesty of the law. It is not an empty rhetoric. Imagine, how much strengthened the rule of law is when your lordships in a rightful case does not one but 2 or 3 things. One, your lordships accepts fallibility. There is a line of cases of actus curiae that we were wrong. Justice Bhagwati, in a case I must thank my learned friend Mr. Sibal to point it out, said to accept fallibility is no act of heroism. So, then the consequence of accepting fallibility must follow. Otherwise, accepting of fallibility is empty. So, your lordship is now coalescing these principles, actus curiae, ibi ius, etc. Imagine, the strengthening of the rule of law when your lordship says, demolish this building, even though we believe it's going to cause a lot of misery. The last one your lordship did took almost 6 months under your lordship supervision because 3 dates were extended. I believe my Lord Justice, Chief Justice was on the bench with us. But it happened because your lordship had a finding, had a view of the merits. And your lordship said, restoration of status quo ante is vital for the necessity for the majesty of law. Now, just see 2 striking examples in the 10th schedule when your lordships did this. We have talked about, but we haven't shown that actual para. It will tell lordships against what odds your lordship still said, no, we must uphold the law. Navam Rebia first and Rajendra Singh Rana second. And this is not at all an upholding of Navam Rebia. We are challenging Navam Rebia on the sole point of disabling. The fact that I rely on Navam Rebia for this, doesn't at all, I'm entitled, not to be hit by a stopple on that at all. Now kindly turn to Navam Rebia, just note the paras. 214.1, 0.3 and 0.4. This was the case, as the lordship remembers. Governor, speaker, preponing date. Your lordship knows now, we've argued for 3 days. Your lordship knows the facts. But see what the court did at the end. It could have found a number of reasons to avoid doing this, or not giving the answer, or postponing it. Deciding not to decide is also a form of adjudication. But when your lordship is convinced of the merits, your lordship decides to decide howsoever severe the consequences. Let's kindly see this now. 214.1 is at iPad, PDF page 1158. 1158, first volume, the compilation first volume. My Lord Receiver, this part my Lord has not seen. This alone vindicates the rule of law. This alone vindicates the strength of the court system, not only the apex court. And this sends a clear message that, howsoever high or whatever the consequence, the consequence must flow if your lordship is convinced. Now, there could be no more scrambled egg in the context of 10th schedule than Navam Rebia. Your lordship's unscrambled it. Please see 214.1. The order of the governor of 9th of December 2015, preponing the 6th session of the Arunachal Legislative Assembly from 14th January to 16th December of previous year 2015, is violative of Article 163, read with 174, and as such is liable to be quashed. The same is accordingly hereby quashed. I'll skip the next one, come to the next after next. 214.3. Now, this is even more important. Well, remember, time had elapsed in between. Navam Rebia was decided on, give me the date. This is important, the date is important. 13th July. 13th July 2016 is the decision. Show the first page. 13th July 2016. These events related to almost 8 months earlier. New government had come in. It was very easy to say so many things and not do this. But the court, if I may say, did the right thing in terms of consequence. All steps and decisions taken by the Arunachal Pradesh Legislative Assembly pursuant to the governor's order and message of 9/12/15 are unsustainable in view of the decisions at 214.1 and 214.2. The same are accordingly set aside. It was argued, as is argued frequently, that even if your lordship holds it illegal, the intervening decisions will not be set aside. Your lordship hears those arguments every day from this side of the bar or whatever. But this is, if I may say, it's the constitutional walking of the talk in case, once your lordship is convinced. Next, in view of the decision at paras point 1 and point 3 above, the status quo ante as it prevailed on 15/12/15 is ordered to be restored. That's 8 months earlier. That's why the date of 13th July versus the date of December 15, there's a hiatus of 8 months. A lot has happened in 8 months, while most of all the government is changed. Otherwise, all these principles, etc., will remain paper principles. Now, in Rajendra Singh Rana, the matter was more directly addressed as a juristic principle about you decide or send it back to the speaker. So that's my next case. Rana is 2007 4 SCC 270. First bunch compilation of case law, PDF page 834. And I will read, with your lordship's permission, paras 12, 44, 45, and 52, 53. It has nothing to do with the law. It is to do with once your lordship is convinced, what is the consequence? It's ibi jus, ibi remedium. It is actus curiae. It is consequence. It is subject to. It is warning. All that is the point I'm reading on.
What page did you say was that, please?
The page starts, the judgment start, para 12 is at PDF page 849. 834, the case starts. Here the argument was made squarely that kindly decide. And the rival argument was don't decide. Let the speaker decide. The respondents, may I read this? The respondents in the writ petition, the MLAs constituting 37 BSP members who left the party, are the appellants in all the appeals, except the appeal arising out of the special leave petition filed by the writ petitioner Maurya. Whereas the respondents in the writ petition, challenging the decision of the majority of the bench, remitting the matter to the speaker, the writ petitioner in his appeal challenges the order of remand to the speaker. The writ petition says order of remand made by the majority on a plea that on the pleadings and the material available, the High Court ought to have straightaway allowed the petition filed by the writ petitioner for disqualification of the 13 MLAs. So squarely the issue is joined. Now come to 43. Sorry, 44, I think. 44 at page 865. Normally, and well, if I may say so, the contentious issues in this case would be far, far more than the contentious issues in my case. Far, far more. Normally, this court might not proceed to take a decision for the first time when the authority concerned has not taken a decision in the eye of the law. And this court would normally remit the matter to the authority for taking a proper decision in accordance with law. And the decision of this court itself takes on the relevant aspects. What is urged on behalf of the Bahujan Samaj Party is that these 37 MLAs, except a few, have all been made ministers. And if they are guilty of defection, with reference to the date of defection, they have been holding office without authority in defiance of democratic principles, and in such situation, this court must take a decision on the question of disqualification immediately. Well, my case has one chief minister, forget ministers. One amongst them is the chief minister, many are ministers. It is also submitted that the term of the assembly is coming to an end, and expeditious decision by this court was warranted for protection of the constitutional scheme and constitutional values. We find considerable force in this submission. This is what the Constitutional Bench is saying. Here, the alleged act of disqualification of 13 MLAs took place on 27th of August. And well, this is only 13. We are 39 in this case. 42 actually, well, there were 3 independents also. When they met the governor and requested him to call the leader of the opposition to form the government. The petition seeking disqualification of these 13 members based on that action of theirs has been allowed to drag on till now. It is not necessary for us to consider or comment on who was responsible for such delay. But the fact remains that the term of the Legislative Assembly that was constituted after the elections in February 2002 is coming to an end on the expiry of 5 years. A remand of the proceeding to the Speaker or our affirming the order of remand passed by the High Court would mean that the proceeding itself may become infructuous. But it may not become infructuous, but it will be great delay. Great delay, and fruits would be enjoyed for even one more second is bad enough. Here, fruits will be enjoyed for months and years. We may notice that the question of interpretation of 10th schedule, the question of disqualification raised earlier in regard to the members of the prior assembly of this very state, which led to difference of opinion between 2 learned judges of this court, and which stood referred to a constitution bench, was disposed of on the ground that it had become infructuous in view of the expiry of the term of the assembly. They will cite that judgment earlier at the footnote. Para 3 of the 10th schedule has also been deleted by Parliament. Though for the purpose of this case, the scope of that paragraph is involved. So, this case involved para 3. In my case, the Lordship doesn't even have para 3. What adjudication is required? Rana involved the pre-existing non-deleted 3. With great respect, considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional. And their holding of the office as ministers would also be illegal, at least after the expiry of 6 months from the date of their taking charge of the office of ministers. We think that the court is bound to protect the Constitution and its values and the principles of democracy, which is a basic feature of the Constitution. This court has to take a decision. Now, this is important. This court has to take a decision one way or the other on the question of disqualification of the 13 MLAs based on their action in August 2003. Lastly, para 52 and 53, where they conclude finally on the result, on the factual result and the result of the case. As we have indicated, para 52 above, para 52 is 869. As we've indicated, nothing is produced to show that there was a split in the original political party on 26th August, as belatedly put forward in a later point of time. But still the plea of split was on 26/8. Now that question your Lordship doesn't have to headache about, no problem. On the materials, the only possible inference in the circumstance of the case is that it has not been proved, even prima facie, by the MLAs sought to be disqualified, that there was any split in the original political party of August 2003 as claimed by them. The necessary consequence would be that the 24 members who later joined the 13 could also not establish a split in the original political party as having taken place on 26th of August. In fact, even a split involving 37 MLAs is not established. There it was in 2 batches. 2 batches there. That was also the inference rightly drawn by the learned Chief Justice. In view of our conclusion, in view of our conclusion that it is necessary not only to show that 37 MLAs had separated, but it is also necessary to show that there was a split in the original political party. The above finding necessarily leads to the conclusion that the 13 MLAs sought to be disqualified had not established a defense or answer to the charge of defection under para 2 on the basis of para 3. The 13 MLAs therefore stand disqualified with effect from August 2003 Supreme Court finding directly at Placetum E. The very giving of a letter to the governor requesting him to call the leader of the opposition to form a government by them itself would amount to their voluntarily giving up the membership of their party. Here they went ahead, they went with the BJP to the governor, in my case today. If so, the conclusion is irresistible that the 13 members of the BSP who met the governor in August 03, who are respondents so-and-so in the writ petition filed by Moria, stand disqualified in terms of 191, read with para 2, with effect from 27th August. If so, the appeal filed by the writ petitioner has to be allowed, even while dismissing the appeals filed by the 37 MLAs by modifying the decision of the majority of the division bench. Hence, the writ petition filed will stand allowed with the declaration that the 13 members who met the governor on so-and-so, being respondents so-and-so, in the writ petition stand disqualified from the UP Assembly with effect from August 2003. The appeals are dismissed. Well, this is really, if I may say so with great respect, the right approach for the very existence and raison d'etre of Mullah's 10th schedule and for the majesty of the law. And Mullah's, no other court can have more powers in this regard than your Lordship's court. Now, Mullah's, let me turn to some of the quotations. Now it will be more focused in terms of just quoting from some judgments. Kindly take a note, we go to the note now. Kindly take a note I have filed.
Already circulated?
A3. It's been sent. It's been sent in the night. Is it?
When you
Serial number is
How serial number A3? I'm
there, it's there. It's there.
A3. It says brief written submission. My name is there, brothers.
Yes, it is there.
Lord, so I put the date for today because there are earlier submissions. This date is today's date, although filed last night, I believe.
Written submissions.
Made today?
Yes, it covers.
So what do I?
Except, Malas, I'm going to add one or two cases, as I've got only two cases, that you also will write in the note itself. Because, Malas, the problem is it's a ever incoming wisdom every minute, Malas. So, may I read, Malas?
Just a moment.
Numbering, because they were actually a separate note added on the top. So therefore, there is some numbering issue, but otherwise, you'll also be able to follow it. Short factual conspectus, the formation of, I'll be very quick in the first part, second part, I'll read it a little more slowly. The formation of a new government on 30th of June was the direct and inevitable result of two orders of the court, a negative injunction of 27th of June, not allowing the Deputy Speaker, a positive order of 29th of June, allowing the trust vote to be held. Order dated 29/6 made the following, I have read that quotation, subject to. Subject to necessarily and only means that A, the court issuing is acting in rem, warning that all those who act after the subject to order do so at their own risk and cost. Any consequence, equities, rights, or new status quo, this is important one, consequence, equities, rights, or status quo, created after the subject to order will be liable to be reversed and status quo ante restored, since the court has fairly put everybody on notice in advance. Well, I'll just read this case. This is important, along with a couple of other cases. But first, let me read on this section first. I'll read this Indore case, fellows. It's important. It's a constitution bench. The consequence of change of government happened fundamentally because the speaker was disabled, fettered in the interim from discharging his constitutional duties. The aforesaid disabling with the order of 27th of June was clearly contrary to a 5-judge bench in Kyoto. I have read that para, Lordship will remember that, 110. Then, Manoj, it disturbed the co-equal and mutual balance between judicial and legislative organs, the latter represented by the Honorable Deputy Speaker. Contrary to detailed Supreme Court judgments, I have quoted them below, Manoj, they are coming. These are only the bullets, Manoj, giving Lordship the propositions. The orders of 27.6 and 29.6 cumulatively and conjointly were not orders
Dr.
merely
Singhvi, if you had warned us forewarned us that you've put it down in writing, I wouldn't have been trying my typing skills, I've typed exactly all this that you have mentioned.
But well, some of this is not going to be there in terms of answer to my Lord's query. The answers to your Lordship's query would have been oral, Manoj, therefore.
Right.
Anyway, so I'll skip, Manoj. Now, there are two principles here which I have not mentioned orally. I'll skip till J, Manoj, Lordship. Come to K, Manoj, K. Then I'll skip again L and M. K is important. I'm sorry, J and K, both are important. J also, Manoj. If in fact an illegality has occurred, and especially after fair warning through subject to orders, the court's powers and arms are always long enough to unravel any situation, and fait accompli cannot be a defense. That's the point. Then K is extremely important, was purposive interpretation. Your lordships have interpreted 10th schedule purposively to plug all collateral and subsidiary loopholes also. Well, directly it is not said, but we find 20 ways of circumventing 10th schedule. Your lordship says, I will interpret purposively to prevent that circumvention. That judgment will come also. The principle of purposive, in light of repeated and comprehensive exhortations by diverse constitution benches and the legislative travaux préparatoire underlying the object behind the 10th schedule and the mischief it sought to remedy, necessitates a purposive interpretation in a holistic perspective to fulfill the true object and spirit of the 10th schedule and not allow it to be rendered a dead letter or an exercise in futility. Then, Manoj, L is Nabam, M is Rana. Right, Manoj? Now, just, fellows, you can skip para 1 in Chauhan's case. The first line of the boldface, Lordship may note, it is trite law that neither the governor nor, for that matter, this court has the power to impinge upon the authority of the speaker to take a decision. This is, Malas, the co-equal aspect. Apart from the Kyoto, no injunction aspect. So this judgment, the Lordship will note, Justice Chandrachud and Justice Gupta's judgment. Thus, the principle of respecting the field of functioning of each constitutional functionary requires the court not to interdict either the disqualification proceedings before the speaker or the proceedings in the House. However, in the present case, that I'll skip, Malas. Then Kyoto, Malas, 125 and 126. This is not that 110. 125, Malas, just turn to for a minute, Malas, it's in PDF 140 of the first comparison.
That's okay, we can read it from here.
Yes, yes.
You can read it out and then go to 120.
Well, this is 126. I'll also just add in hand. 125 is important also. I forgot to put that. Just note that. The purpose of interlocutory orders is to preserve in status quo the rights of the parties so that proceedings do not become infructuous by any unilateral overtax by one side or the other. Then was Samir Bhojwani, a judgment to which my Lord, the Honorable Chief Justice was a party, though authored by Justice Khanvilkar, 2018. Distinction between molding of relief and granting of mandatory relief held that interim relief can be granted only to restore the status quo and not to establish a new set of things different from the state which existed at the date when the suit was instituted. You've created a new status quo that's very different from maintaining a status quo.
Yes.
Then Malas Bommai in para 8, para 115, it has, however, to be made clear, this is Malas 3 judges out of the 7, and it's part of the concurring. It is, however, to be made clear that the interlocutory relief that may be granted to such challenge to prevent the frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. This is even more important than Kyoto. This is the origin of Kyoto in the 10th schedule. Bommai was not 10th schedule, but the principle is important. And this is one of 7 judges. No, 9 judges. 9 judges. 9 judges. And this is the principle which Kyoto applied to the 10th schedule. Our conclusion that Justice Sawant's judgment is part of the majority, core majority. Our conclusions, therefore, may be summarized under: if the proclamation issued is held invalid, then notwithstanding the fact that it is approved by both houses of parliament, kindly note this, it will be open to the court to restore the status quo ante to the issuance of the proclamation and hence to restore the assembly and the ministry. In appropriate cases, the court will have power by an interim injunction to restrain the holding of fresh elections to the assembly, pending the final disposal of the challenge to the validity of the proclamation to avoid fait accompli and the remedy of judicial review being rendered fruitless. Whereas Mr. Hegde never saw to live to see this benefit because governments changed twice over by the time Bomai was delivered. But subsequent to that, your lordships will notice that the exercise of 356 has decreased a lot because the lordship has been very prompt from the Bihars, the Rameshwarnaths, the Uttarakhonds, the Jharkhands to the Karnataks. It's the promptitude of the court which has reduced the use and abuse of such articles. Because well, retribution this way or that way, in terms of judicially well, deciding it, is quick. In the old days, well, it used to take time. Now, well, this Kavita Trehan is the actus curiae principle. I'll not go to it, just read the quotation. In regard to the law of restoration of loss or damage caused pursuant to judicial orders, they quote the Privy Council, one of the first and highest duties of the court is to take care that the act of court does no injury to any of the suitors. And when the expression the act of court is used, it does not mean merely the act of the primary court or intermediate court of appeal, but the act of the court as a whole, from the lowest which entertains to the highest which finally disposes of the case. Then they cite this Kedarnath. Under 144, this is the but for test. Restore the parties to the position in which they would have occupied but for such decree or part thereof. The but for test it is called. Nor indeed that this duty or jurisdiction arise merely under the said section. It is inherent in the general jurisdiction of the court to act rightly and fairly according to circumstances. Then, they consider the submission. I'll skip that. Come to the end of that para 23. It's a long para. The boldface is sufficient, that such a thing was achieved by an ex parte order tends to shake the litigant's face in the judicial process. That will not apply. Navam Rebia, I will skip. Now, here, before your lordship comes to the object, that is para 13 onwards, there are two important judgments your lordship will note. One is Bhullar. This is not there. Lordship may note it down on the side, these three judgments. This is not there. No, but my proposition is not there. Your lordship may, it's not cited here. First is Bhullar, Devendra Bhullar, the death convict case. 2011-14 SCC 770. It's the PDF 926. And the relevant paras are 107 and 108. Please turn to that. If there is an initial wrong, the court says, I'm sorry, 107 and 108. It's a very important principle. Kindly turn to PDF page 967 in the first compilation. Right? First compilation. 966.
What's the proposition?
If the initial wrong is found, then all consequential things must be adjusted so as to rectify that initial wrong. And second sentence is very important. This principle applies equally to judicial orders. This is very important. Please turn to 107, 108, para number. Which page? 107 is at page 966. Put it here. It is a settled legal proposition that if the initial action is not in consonance with law, I'm sorry, does my lord have it? My lord doesn't have it. It's on substantial and consequential action. The page is 966 bottom. It is a settled proposition of law that if initial action is not in consonance with law, all subsequent and consequential proceedings would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim, it is given there, meaning thereby that the foundation has been removed, structure, work, falls, comes into play and applies on all scores. Now, the next para is more important. Next para. In Badrinath and Kerala, this court observed that once the basis of a proceeding is gone, all consequential acts, actions, orders would fall to the ground automatically, and this principle will apply to judicial, quasi-judicial, and administrative proceedings equally. This is the meaning of majesty of the law. Well, I'll just take a little bit of time on Tuesday. I won't take very long.
Rise. On Tuesday.
Very deeply obliged.